Okay, people. I want to big up to VMAC for emailing me this, and we'll go for it together. Exclusive Advisory Agreement. This agreement, effective as of the day of March 2012, between whatever fighter, his name has been scratched out obviously there, hereinafter referred to as Athlete and Haymon Development Incorporated, hereinafter referred to as Advisor. You gotta watch this legal language. Witness, okay, I don't know how you pronounce that. For and in consideration of the mutual promises, covenants, representations, agreements, and conditions as set forth herein, the parties hereto agree as follows. 1. Exclusive advisory rights. A. Advisor shall have the sole and exclusive right to render services on behalf of an athlete in connection with athlete's participation in professional boxing contests or exhibitions, and in connection with athletes' participation in entertainment, performances, personal appearances, and endorsements and or sponsorship opportunities arising out of or related in any way to athletes' boxing career. B. Advisor here agrees to advise and counsel athlete in the development and advancement of his professional boxing career. Exercise best efforts to secure remunerative boxing contests, exhibitions, secure proper training facilities and equipment for athletes. Publicize, promote the talents and abilities of athlete throughout various forms of media. Attempt to secure commercial endorsements, personal appearances and or performances as a performer, movies, stage, radio, television, or forms of media and entertainment. To secure such ends, athlete hereby makes and appoints advisor as his agent and attorney in fact for him, and in his name to execute and deliver such contracts on behalf of athlete, subject to the written approval of athlete. Term of agreement. A. Original term. The original term of the agreement shall be for 3 years beginning of the date of the first fight after the effective date of this agreement, subject to paragraphs 2b, 2c herein. The original term and any extension periods are collectively the term. B. Extension of term. If at any time during the term of this agreement athlete becomes physically, mentally, or legally incapacitated to such an extent that he is rendered unable to participate in professional boxing. Contests, then, for purposes of computation of the expiration periods of this agreement, the terms of this agreement shall be deemed to be automatically suspended for the period of time during which athlete is incapacitated as defined above. Such period shall be automatically added to the term of this agreement. C. In the event that athlete during the original term of this agreement earns aggregate purses in excess of whatever dollar amount, the original term of this agreement shall be extended for a period of 2 years. If at any time during the original term of this agreement, athlete enters into multi-fight agreement with media outlet, the original term of this agreement shall be extended for a period of 2 years, or for a period sufficient to make the term of this agreement coterminous, never heard of that word, with the term of the media agreement, whichever is longer. The term shall be subject to all applicable state, federal laws, and may not be for a term inconsistent with said laws, but in all other respects shall be valid and binding upon all parties. Under no circumstances shall the term of this contract, of this agreement, exceed 7 years beyond the effective date of the agreement. Advisor's compensation. Advisor's compensation for the services he shall render pursuant to this agreement shall be 15% of all sums of money and other remuneration in any other form whatsoever paid or credited to the athlete for his participating in professional boxing contests, exhibitions, and other endorsement, sponsorship, personal appearances. Said 15% shall be payable only for bouts for which athlete receives a minimum purse of 100,000 or greater. Okay. Representations and warranties. A. Advisor agrees that he cannot and will not cause athlete to become legally bound to take part in professional boxing contests or exhibitions, including entertainment performances, personal appearances, endorsements, sponsorship without the prior written approval of athlete. B. Advisor agrees not to incur any expenses on behalf of athlete without athlete's prior approval. The selection of the head trainer is at the sole discretion of the athlete. C. During the term of this agreement, athlete agrees to render services solely and exclusively for advisor and agrees that he will not take part or negotiate for any professional boxing contest whatsoever without first obtaining the written approval of advisor. Kind of throws a spanner in the talking points about the PBC fighters being free agents. We'll discuss it though. D. Athlete hereby represents and warrants that he is free to enter into this agreement and that this agreement does not breach or violate any other agreements to which athlete is a party. Athlete hereby expressly agrees to indemnify and hold advisor harmless against any damages, liabilities, costs, or expenses, including legal fees and expenses, incurred by or threatened against advisor as a result on any breach of these representations and warranties. E. Advisor hereby represents and warrants that he is free to enter into this agreement and that this agreement does not breach or violate any other agreements to which advisor is a party. Advisor hereby expressly agrees to indemnify and hold athlete harmless against any damages, liabilities, costs, or expenses, including legal fees, incurred or threatened by athlete as a result on any breach of these representations and warranties. Did I read that already? F. Athlete acknowledges that the advisor has no present or future responsibilities or duties with respect to the conduct of athlete's personal, financial, business affairs, and that the advisor's duties are limited solely to boxing and entertainment-related matters. Athlete expressly agrees to indemnify and hold advisor harmless against any liabilities, damages, costs, or expenses, including legal fees with respect to claims or litigation related to said personal, financial, and business affairs. 5. Severability. Another word I haven't heard of. Let's look it up quickly. In law, severability, sometimes known as salvatorius from Latin, refers to a provision in a contract which states that if parts of the contract are held to be illegal or otherwise unenforceable, the remainder of the contract should still apply. Whew, really? That's deep, bro. It is understood and agreed by the parties hereto that if any section, term, or provision of this agreement is held by any court or other applicable authority having jurisdiction to be illegal or in conflict with any local law or policy of any state, province, or county where athlete is required to perform, the validity of the remaining portions or provisions shall not be affected, and the rights and obligations of the parties shall be construed as if the agreement did not contain the particular section, term, or provision held to be invalid. 6. Entire agreement. This agreement constitutes the entire agreement between the parties. All other agreements related hereto that are not contained herein are hereby terminated. 7. No oral modification or changes. This agreement may not be enlarged, modified, or altered except in writing by the party or parties to be charged therewith. 8. Execution of further papers. The parties hereto recognise and acknowledge that the rules and regulations of the various state, country, territorial athletic commissions and or sanctioning organisations differ and are sometimes inconsistent. Therefore, each party to this agreement agrees to execute and to deliver any additional documents and instruments and to perform such additional acts as may be necessary or appropriate to effectuate these words, man. Carry out and perform all the terms, provisions, and conditions of this agreement and the transactions contemplated by this agreement. It would be great to get a legal person to really break it down. It really would. 9. Unique services, injunctive relief. A. Athlete hereby acknowledges and agrees that the services as set forth in this agreement as rendered by him are of a special, unusual, extraordinary character, giving them particular value, the loss of which could not be reasonably and adequately compensated by damages in an action to injunctive and other equitable relief to prevent any material breach or default by athlete hereunder, which shall be in addition to and without prejudice to any other rights or remedies that advisor may have. B. Advisor hereby acknowledges and agrees that the services as set forth in this agreement as rendered by him are of a special, unusual, extraordinary character, giving them particular value, the loss of which could not be reasonably and adequately compensated by damages in an action at law. Advisor therefore agrees that athlete shall be entitled to injunctive and other equitable relief to prevent any material breach or default by advisor hereunder, which shall be in addition to and without prejudice to any other rights or remedies that athlete may have. 10. Choice of law. The parties acknowledge that this agreement has been negotiated and entered into the state of Ohio. Notwithstanding the foregoing, the parties agree that the laws of the state of California applicable to contracts executed and to be fully performed in the state of California shall govern this. Agreement. Further execution of this agreement shall constitute each party's agreement that any dispute, claim, or controversy arising out of or relating to this agreement, or the breach, termination, enforcement, interpretation, or validity thereof, including the determination of the scope or applicability of this agreement to arbitrate, shall be determined by arbitration in Los Angeles, California, before a single arbitrator administered by JAMS pursuant to its streamlined arbitration rules and procedures. This clause shall not preclude parties from seeking provisional remedies in aid of arbitration from a court of appropriate jurisdiction. The reasonable attorney's fees, as determined by the arbitrator of the prevailing party, shall be paid by the non-prevailing party. The award or decision rendered by the arbitrator shall be final, binding, and conclusive, and judgment may be entered upon such reward by any court having jurisdiction. 11. Notice. Any notice provided for under this agreement shall be given in writing and shall be addressed and sent by registered or certified mail. Return receipt requested, postage prepaid, and by confirmed facts as follows. Athlete. Copy to Advisor Al Haymon, Development Incorporated, 16030 Ventura Boulevard, Suite 380, Encino, California, 91436, fax 818-990-0059, copy to. It is the duty and responsibility of each party to notify the other parties to this agreement of any address changes for purpose of notice and service. 13. Termination. A. Advisor shall have the right to terminate this agreement immediately upon A. material breach of this agreement by athlete. B, written notice to athlete of a material breach of this agreement by athlete. C, athlete's failure to cure any such breach within 30 days of receipt of such written notice. B, if either party commits or is indicted for or a complaint is filed against a party for committing a criminal act or offence under any federal, state, or local law, the other party may, at his sole discretion, in addition to any other rights he may have at law, terminate this agreement without any further obligation. C, athlete shall have the right to terminate this agreement immediately upon A, material breach of this agreement by advisor. B, written notice to advisor of a material breach of this agreement by advisor. And C, advisor's failure to cure any such breach within 30 days of receipt of such a written notice. 14. Non-exclusivity. Nothing herein shall prevent advisor from managing or advising any other fighter in any other weight class. Assignment. Either party may assign his rights and obligation under this agreement to any other entity in which he shall have ownership interest, so long as it will not have the effect of abrogating, never heard of it, the personal service each party agrees to provide hereunder. 16. Independent contractors. The parties acknowledge that they have entered into the business arrangement described in this agreement as independent contractors and not as employer and employee, partners, principal and agent, or joint ventures, and accordingly this agreement shall not be cited or relied upon by the parties hereto or any third party as creating any business relationship between the parties other than that of independent contractors. 17. Section headings. The headings of articles, sections, and other subdivisions hereof are inserted only for the purpose of convenient reference. Such headlinings shall not be deemed to govern, limit, modify, or in any other manner affect the scope, meaning, or intent of the provisions of this agreement or any part or portion thereof, nor shall they otherwise be given any legal effect. Additionally, this agreement shall be construed against the party causing its preparation, but shall be construed as if all parties prepared this agreement equally. 18. Athlete's legal representation. Athlete hereby acknowledges that he has been advised by advisor and given ample opportunity by advisor to consult with an attorney before executing this agreement. Accepted and agreed by the parties hereto. Athlete, name scribbled out, advisor Al Haymon Development Incorporated, dated by the boxer and Al Haymon. And there you have it, folks. And there you have it. I'm not sure if there's anything sinister there. I don't have no point of reference to compare it to either. I don't think he's doing anything underhanded with the paperwork. He's too smart, that being a Harvard grad. I just don't like the way certain fights are not happening on the PBC's end. That's my argument. But if there's anything you can decipher out of that, and let's not just try to be negative for the sake of it, and let's talk about it. Good talking point, and let's go from there. If you're gonna be here and try to act like I know it all and cause confusion, then block. But apart from that, let's talk about it.